Jimmy Buffett built a $275 million empire. He had a trust in place, and yet his estate still ended up in court. If someone with his resources and world-class advisors can fall into this trap, what does that mean for the rest of us? Buffett's story isn't just about celebrity drama. It's about a core truth of estate planning. A trust is only as strong as the way it's designed, funded, and managed. And the most overlooked piece of that puzzle, the trustee. Let's start with this. What does a trustee actually do? Most people think naming a trustee is just picking a family member or friend, maybe the oldest child. But a trustee's role is massive. They manage the entire estate. They decide how assets are invested, when and how beneficiaries receive distributions, and they deal with creditors, taxes, and sometimes lawsuits. In California, trustees are legally bound by what's called a fiduciary duty. That means they must act in the best interests of the beneficiaries. But here's the hard truth. Being legally required and being capable are two very different things. I've seen trustees who mean well, but are overwhelmed by the job. They miss deadlines, they mismanage paperwork, they don't communicate. Even small mistakes, like failing to send a notice or forgetting to account for income, can snowball into thousands of dollars in costs and months of delay. And when beneficiaries are left in the dark, suspicion grows. That's how family conflict erupts, and the only option left is to drag everything into court. And that's exactly what happened in Jimmy Buffett's estate. Not because there wasn't a trust, but because the accountability piece wasn't designed well enough. Here's where design matters. A trust isn't just a set of papers, it's a blueprint for how your legacy is carried out. And if you design those instructions carefully, you can give your beneficiaries tools to hold the trustee accountable without having to run to court. So how do you do that? Sometimes it means requiring the trustee to send regular accountings, annual, or even quarterly reports that lay out exactly what's happening with the money. That way, beneficiaries aren't guessing and they don't feel like someone is hiding information. Sometimes it means giving the beneficiaries a clear process for removing or replacing a trustee if things go sideways. For example, you can write into the trust that if a trustee fails to provide reports or mismanages investments, the beneficiaries can vote to remove them and appoint a successor. Oftentimes, it makes sense to name a trust protector, a neutral third party with the authority to step in and fix problems. That could mean replacing the trustee, resolving disputes, or even adjusting the trust if laws change. But here's the key. The right accountability structure isn't the same for every family. It depends on who your beneficiaries are and who your trustee is. I can't tell you how many times I've had families say to me, "We knew he was irresponsible, but we never thought he'd actually do that." Or, "We knew she was difficult, but we didn't think she'd go that far." The truth is, when money and grief collide, people don't always act the way you expect. And this is where working with an attorney who takes the time to understand your family dynamics matters. I've seen it all. Siblings who fight, trustees who freeze, and families who suddenly get litigious. Lawyers see every day what doesn't work, and we can spot the red flags that love and optimism often make you overlook. That perspective is what allows us to say, this person might look like the safe choice, but here's why they may not be. Or, if you really want this child to serve as trustee, here are the guardrails we need to put in place to make sure the plan actually works. Let's look at two families as an example. The first family creates a simple trust. They name the oldest son as trustee because he's the oldest. That's it. There's no accountability structure, no oversight. He's busy, he's overwhelmed, and he doesn't communicate with his siblings. The siblings start to resent him, suspecting that he's dragging his feet or maybe even hiding something. Within months, they're hiring lawyers. The trust ends up in court, and instead of grieving together, the family is divided. The second family also creates a trust, but their attorney helps them design it with accountability. The trustee is required to provide annual accountings. If the trustee fails to perform, the beneficiaries can vote to replace them. There's even a neutral trust protector who can step in if things break down. When the parents pass, the siblings may not always see eye to eye, but the plan is clear. Everyone knows the rules, the trust works smoothly, and the family stays intact. That's the difference between a trust that works and a simple trust that fails. And let's not forget the other major pitfall, funding. Matthew Perry's estate showed us that even with a trust, if you don't transfer your assets into it, those assets still end up in probate. And a trust without funding is like an empty box. It looks good on a shelf, but it doesn't hold anything. But Buffett's estate shows us something else. Even when the box is full, if the person holding it isn't accountable, the plan can still fall apart. So what does this mean for you? It means a trust is not a one and done document. It has to be funded, and it has to be designed with real accountability. Without both pieces, your family could still end up in court. When I work with families, I don't just draft documents. I focus on design, choosing trustees who can truly handle the role, building in structures for oversight, and making sure beneficiaries have ways to stay informed. And I provide systems for funding and organization, so the trust doesn't become just another empty box on a shelf. This isn't about mistrusting your family. It's about protecting your family from the kind of pressure that can break relationships. Because when expectations are clear, when oversight is built in, families can grieve in peace instead of fighting in court. So here's my question for you. If something happened to you today, is your trustee really prepared to step in? Do your beneficiaries have the tools to hold them accountable without hiring lawyers? Or is your plan just words on paper waiting to be tested? If you're not sure, you're not alone. Most families never think about these questions until it's too late. But you don't have to wait for a crisis. I offer a short 15-minute intro call just to see if I can even help you. From there, we'll know whether the right next step is a trust checkup, a full planning session, or maybe nothing at all right now. Either way, you'll walk away with clarity. Because as Jimmy Buffett's $275 million estate shows, even the best plans can fail if accountability is missing. And the differences between family peace and family conflict can come down to one decision: designing a trust that actually works.